All right, and we will recognize the gentleman from Ohio, Mr. Jordan.
Thank you, Mr. Chairman. Attorney General Lynch, on February 2nd, 2014, Kate Duvall, Chief Counsel to IRS Commissioner John Koskinen, learned that Ms. Lois Lerner's hard drive had crashed and they didn't have all her emails. Mr. Koskinen and the IRS waited until June of that year, June of 2014, to tell Congress. In that 4-month time period between when they learned that her hard drive had crashed and they didn't have all her emails and June when they told us, in that 4-month time period, Mr. Koskinen testified twice in front of Congress and did not disclose the fact that they knew her hard drive had crashed. 1 month later, after they learned her hard drive had crashed, in March of 2014, March 4th of 2014, the IRS destroys 422 backup tapes. So just so you understand the fact pattern, they know on February 2nd, Lois Lerner's hard drive has crashed. They don't have all her emails. 30 days later, they destroy 422 backup tapes. And they destroy those 422 backup tapes with 3 preservation orders in place. In fact, one of those preservation orders came from the Justice Department. 10 months before that, you had told them, hey, preserve all the documents, preserve all the emails. We got an investigation going on. There were 2 other preservation orders as well. So 3 preservation orders and 2 subpoenas. Now, that sure looks like John Koskinen and the Internal Revenue Service concealed information and destroyed information. But just last month, you guys sent us a letter telling us you're not going to prosecute anyone in the IRS targeting scandal, and you specifically say in that letter, our investigation revealed no evidence to deliberately conceal or destroy information. So here's what I can't figure out. They learn on February 2nd, 2014 that Lois Lerner's hard drive had crashed and they don't have all her emails. 30 days later, with 3 preservation orders and 2 subpoenas in place, they destroy the backup tapes. So if that's not evidence of deliberately concealing and destroying information, what is it?
Thank you, Congressman. With respect to the matter that you've raised, as we set forth in our letter, we did review the issues surrounding the Ms. Lerner's emails and the backup tapes. As with every criminal investigation, we are looking for evidence of criminal intent, and we are looking for evidence of the specific reasons for why the actions that you note.
How many times do you have direct evidence of intent in any type of other fraud investigation? I mean, you weren't going to get something. What were you looking for? An email where John Koskinen sends an email to the guys in the tape room and he says, destroy the tapes? You had 3 preservation orders. One of them came from the Justice Department. They knew there were problems with their hard drive and that they didn't have all her emails, and 30 days after that, they destroyed 422 backup tapes. That's not enough to take it to a grand jury?
Certainly, Congressman, it certainly was a matter that was under review, and as we've outlined in our letter, the findings of that review.
If it wasn't deliberate intent to destroy and conceal, what was it?
Congressman, as we've outlined in our letter, the findings that we had based on those actions.
Here's what you said in your letter. Justice Department's investigation uncovered substantial evidence of mismanagement and poor judgment. What I just described, was that evidence of mismanagement by John Koskinen?
Well, Congressman, I'm not going to attribute it to just one individual, because I believe that certainly there would be others that would have been looked at.
Was it evidence of poor judgment when Mr. Koskinen's chief counsel knew that Lerner's hard drive had crashed? He comes and testifies in front of Congress and doesn't tell us that and waits 4 months to tell us? Was that evidence of poor judgment?
I can't speak to what was in his mind when he testified before you. What I can speak to is the information that we provided to this committee outlining the steps that were taken in the Department of Justice investigation.
What was it going to take?
And the conclusions that were drawn. As we've indicated.
Here's what the American people want to know, Attorney General. What was it going to take before you would take this to a grand jury? Would Mr. Koskinen, would he have had to wait 5 months before he told us? 6 months before he told us? 8 months before he told us? Would they have had to destroy 423 backup tapes? 450 backup tapes? Would they have destroyed every single backup? Would they have destroyed more evidence? What was it going to take before you were going to take this to a grand jury with 3 preservation orders in place, 2 subpoenas in place? They have knowledge that there's problems with their hard drive, that they don't have all their emails, and they destroy the backup tapes. I mean, if that fact pattern doesn't warrant going to a grand jury and prosecuting, tell me what would.
Certainly, Congressman, that fact pattern was part of the investigation, as were a number of other facts in there. And as we outlined in our letter, we outlined not only the investigative steps that were taken, but the conclusions that we drew from.
So who are you referring to when you say substantial evidence of mismanagement and poor judgment? Who? Seems to me the guy at the top is the guy responsible. So are you saying Mr. Koskinen had substantial evidence of mismanagement when he didn't inform Congress and when he destroyed 422 backup tapes. Is that substantial evidence of mismanagement on the part of John Koskinen?
I'm not going to attribute it to a specific
Who would you
individual.
attribute it to? Someone's got to be responsible, because let me ask you one last question, if I could, Mr. Chairman. So you sent a preservation order to the IRS in May of 2013. March of 2014, they destroy 422 backup tapes. Now, if a private citizen gets an audit notice from the IRS, and then 10 months later they destroy the evidence, are they going to be prosecuted?
It would depend upon the evidence of intent and why they
Really? I bet the average American says, of course they're going to be prosecuted, and yet you guys with that fact pattern wouldn't take it to a grand jury. Who mismanaged what? That's the question I want to answer. Who's responsible? Someone has to be.
I think we've outlined in our letter the
No, you haven't.
findings
You
of this
said some.
investigation.
I want to know if it's Mr. Koskinen, the guy at the top, the guy who runs the IRS, the guy who was presiding over the IRS when we destroyed the 422 backup tapes. Is he responsible?
As we've indicated in our letter, there was substantial mismanagement. As we've outlined and when we indicated we would provide this information to the committee, we're also happy to provide a briefing to the committee on other questions that you may have about this matter.
Gentleman's time has expired. The chair will now recognize the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. General Lynch, I want to commend you and the Department of Justice on the fact that 70 individuals have been charged since 2013 for conduct related to foreign fighter activity and homegrown violent extremism. General Lynch, this committee has previously heard how ISIL and other terrorist organizations field potential recruits in publicly accessible social networking sites via encrypted messaging platforms, and also over voice-over internet apps. Are these encrypted private messaging platforms and also voice-over internet apps hampering the ability of the department to quickly ascertain and address threats to national security, and if so, in what ways?
Well, Congressman, thank you for the question. Certainly when individuals choose to move from open means of communication to those that are encrypted, it can cause a disruption in our ability to use lawful legal process to intercept those communications, and does give us concern about being able to gather the evidence that we need to continue in our ongoing mission for the protection of the American people.
How so?
Well, with respect to individuals in this country, what we have seen is communications. This is in regard to specific cases. We've seen communications between them and individuals urging them to commit acts of violence, acts of terrorism, and then those individuals dropping from one type of communication to an encrypted method of communication, and we no longer have visibility into those discussions. And so,
well, when you say no longer have visibility into those discussions, can you break that down and explain exactly what you mean?
Certainly. Typically, we would, with a lawful court order, go to a communications provider and, focusing specifically on individuals against whom we had probable cause to believe were involved in criminal activity, including terrorist activity, obtain the authorization to review their communications in the past as well as on an ongoing basis. When individuals move to an encrypted platform, one that is not accessible by the provider themselves, then we have a situation where we're not able to have our court orders handled in the typical way. That is to say, we're not able to receive that information and ascertain what these individuals are planning, and also, just as importantly, with whom they're planning these actions. And so we rely on other methods and means, but that is a loss of an important means and an important law enforcement tool.
Is there any way that the department can overcome the use of encrypted data and voice communications by terrorists who are trying to recruit within the borders of the United States, or a terrorist plot taking place between persons inside the United States? Take, for example, the terrorist incident in Paris this past weekend, where I heard one expert say that he would be shocked if the terrorists were not using encrypted communications, perhaps even during the terrorist events. How can the department thwart that kind of activity taking place here on United States soil, given the fact that we have these encrypted communications?
Well, certainly it makes it very challenging. Our approach has been to work with the electronic companies, the internet providers, on a case-by-case basis and help them find a way, or work with them to find a way to allow them to respond to the valid legal process. And certainly we're having conversations with the industry as a whole to make sure that they can in fact comply with legal process and provide us the information that we need. We rely on other means of surveillance, other means of gathering intelligence about those individuals and their associates, but it does cause us the loss of a very valuable source of information.
Okay, with that, I will yield back and thank you for your testimony.